Hi, I'm Stephanie. I'm going to talk about last week's decision of the Court of Appeal in Asda Stores and Leeds City Council. It was a decision which concerned my client, Leeds City Council's decision to grant planning permission to the interested party. The interested party wanted planning permission to construct some new retail units on a site just outside Middleton District Centre in South Leeds. Those new retail units will include a Lidl and a B&M stores, and the owners of the site next door were Asda, the claimants in the High Court, and Appellant in the Court of Appeal, who weren't too happy about the competition arriving next door. The wider implications of the decision concern the interpretation of paragraphs in the NPPF, particularly paragraphs 89 and 90, although not limited to those paragraphs for reasons we'll come on to. Now, 89 and 90 are obviously about retail impact, and what was really before the committee in this decision was the significant adverse effect on Middleton District Centre that would be caused by this new retail unit, number of new retail units just outside. It was all agreed that that impact would be a significant one, and therefore NPPF paragraphs 89 and 90 say that in those circumstances permission should be refused. The wording of the development plan policy was slightly different, but the wording that was before the court for consideration was what to do with these really strong words in NPPF 89 and 90 should be refused. So we all agreed that the criteria for refusal in 89 and 90 was met. It was just then, what do you do with it? Is there a requirement or a mandate to refuse? Now, I think this has much greater implications for other parts of the NPPF. For example, 89 and 90 are not the only parts where the NPPF says that permission should be refused in certain circumstances. We now have NPPF 130, which says that permission should be refused where there's poor design. And there are other examples of strong wording in the NPPF. Where a refusal is requested. There's also numerous policies in the NPPF which say that particular weight should be given. So, for example, greenbelt weight, substantial weight should be given to greenbelt harm. Does that mean that the decision maker would err in law if they fail to afford substantial weight to harm to the greenbelt? Just as the question before the Court of Appeal here, did my client's Leeds City Council go wrong in law by failing to refuse that application because there was a significant adverse impact? And the answer of the Court of Appeal was essentially no. Everything has to be fed into the section 38.6 balance. So the NPPF, either as a whole or when we're just talking about a particular paragraph, it is but a material consideration. And you might remember the wording from Hopkins Holmes, it's all just guidance. It's not even development plan policy, but in any event, it's all a material consideration that has to sit within the statutory framework and has to sit within the section 38.6 balance. It can't be that through strong wording alone, the NPPF can mandate an outcome to the whole section 38.6 balance, because that wouldn't be in keeping with the statutory scheme. So however strong the wording gets in the NPPF, it is only a material consideration. So it's open to the decision maker to depart from that, just as they would with any other policy departure if reasons are given. And here there was an attack to Leeds City Council's reasons, but they were found to be solid too. So the real and a broader implication of this case is, well, what happens when we get this really strong wording in the NPPF or even in a development plan policy? Is that bound to hold the day if it says, well, in certain circumstances, permission should be refused? And the answer is no. That does leave us with some open questions about, well, what does a decision maker have to do to show that they've taken into account the strong wording? Because there's obviously a vast spectrum of wording that gets used both in the NPPF and in development plan policies, everything from, that won't be supported or that's not encouraged, to wording like the NPPF paragraphs before the Court of Appeal here, 89 and 90, should be refused. And there's everything in the middle as well. So how does a decision maker grapple with that spectrum of wording? And my submissions to the Court of Appeal were really that, well, that strength of wording needs to be acknowledged. It needs to be clear from the decision maker's report that they've had, they've given that proper consideration and they've understood the policy. Nevertheless, it remains open to them to say, well, I've read it, I've understood it, but that's not what I'm going to do. And that's essentially what the Court of Appeal said was open to the decision maker as well. I hope that canter through the recent Court of Appeal decision's been somewhat helpful. As I said, I do think it does have some wider implications, particularly for parts of the NPPF which seek to mandate weight as well as to mandate an outcome. I think the Court of Appeal's decision should be interpreted as saying, well, neither of those types of policy or paragraph in the NPPF can indeed mandate a weight or mandate an outcome when viewed against the background of the Section 38(6) balance as a whole. It's also another decision coming out of the courts which says that, well, look, planning judgment it is really everything. The decision maker, as long as they're doing something rational and clear and explaining what they're doing, their decision isn't properly open to challenge very easily. So it's another decision which just shows how difficult it can be to bring successful judicial reviews against council's decisions to grant planning permission. So depending on which side you're on, that's either good news or terrible news. Anyway, I hope that you found it useful, and thank you very much for your time.